to thank the Annie Casey Foundation as well as Nate Bayless for, making this an important enough conversation for us to be here with this webinar. I want to thank Angie and Rachel also for making time to be here, and Beth and Mark for doing all the technical stuff for us to be able to do this with you today. This is the Non-Citizen Youth in the Juvenile Justice System, What You Need to Know in 2018 webinar. What we're going to do for the next hour is we're going to have Nate Bayless do a welcome framing of this webinar. We're going to, he'll also, because he needs to leave, we'll do a few questions if folks have some questions for him before he leaves. Then we will have Angie and Rachel, both from the Immigrant Legal Resource Center, Angie being the author of this report, who will then present for about 30 minutes. And they have some slides that they will share with you. We will reserve about 15 minutes for questions and answers, and then we will close up. Logistics is that you will receive a survey right at the end of this webinar, and please, on behalf of Beth, we want you to make sure that you take the survey. If you have any logistical problems, please add that into the chat box and somebody will respond to you. All right, I think we're ready to move on. My name is Marcia Rincon-Gallardo. I will be the moderator, particularly at the end for the questions and answers. Nate, you're next.
Great. Thank you so much, Marcia, and thank you to everybody for being part of this. I really want to start off just with an appreciation that knowing that everybody's plates are already full in your jobs in the juvenile justice system before immigration enforcement placed new burdens on all of you. And, you know, you're on the front lines working with our kids and our families, trying to help them oftentimes in really difficult situations. And right now, I think none of us are mistaken that the stakes are high, that immigrant youth face serious and negative consequences such as separation from family and community and removal from the country even. I assume you've joined this webinar because you're aware of the urgency. You know that recent shifts in U.S. immigration enforcement policy are threatening our core values and putting non-citizen youth in the justice system at greater risk of arrest, immigration, detention, and deportation. It's up to all of you. It's really up to all of us to hold true to the values of our field by supporting all young people in our communities and working to ensure that all of them have a bright future. I think that's why, of course, you're working in juvenile justice in the first place, because you're committed to brighter futures for all kids, especially the ones facing the longest odds, and that's certainly true of our of young people in immigrant families. You have a unique opportunity to support these young people rather than expose them to setbacks that compromise their ability to reach their full potential. And really, in order to do that, it's not enough just to have those values. You have to know the law and your options under the law. 4 years ago, we released a guide for working with non-citizen youth in the juvenile justice system because it felt so timely then. And yet, as urgent as it was, in some ways it feels like it was before its time in terms of its uptake and the way that many in the JDAI network responded, which is that we just didn't promote this in the way I think that we really should have then. I think none of us can say that this issue lacks urgency today. And with that in mind, the Casey Foundation turned to experts at the Immigrant Legal Resource Center. We are very, very lucky to have our featured speakers today, Angie Young and Rachel Prandini. We're just so fortunate that the work that they did on this guide that I think both gives everybody the kind of legal background and then also I think really concrete guidance for all of us working in the juvenile justice field, and particularly for those of you working in juvenile justice systems about what not only you can do, but what you should do when it comes to supporting non-citizen youth and families. So again, for those of you who are on right now and for those who are watching after the fact, you know, this is a critical time, and it's a critical time for lots of kids. We say that about all young people in the juvenile justice system, but in particular, while focusing, whether you're living in Arizona, where this issue might have been on your radar for decades, or whether you're living in Montana and you haven't thought a lot about immigrant youth and families, this issue matters today. And so, again, thank you for participating. We are eager to hear from you, as Marcia said. Give us feedback about the webinar, and I hope all of you read the update to the guide, and then really enjoy the conversation today. So thanks, and I can take any questions now if there are any.
Nate, if you want to wait just a few seconds here.
Yeah, I'm not going anywhere.
I don't necessarily see any questions, but maybe someone's writing one. In the meantime, thank you for your welcoming remarks and framing this.
And one last thing, actually, I just wanted to say was is that, you know, this is as an issue of supporting immigrant youth and families is not just a juvenile justice issue here at the Casey Foundation. And I think I'd encourage people, if they, in addition to reading our non-citizen guide, the Casey Foundation's Kids Count Race for Results report last year, which you can find on our website, and we could certainly send a link to, was specifically written about providing passive opportunity for all children in this country, and focused also on immigrant children. And so this is not just a justice issue, obviously, and it's one that, if we really are upholding the values that this foundation was created from, and which JDAI was created from, that this is a population that we just simply can't ignore. Thank you.
I really appreciate that. And we do not see any questions right now, and so I just want to thank you for having been here with us.
Great. Yep.
And thank you for your words. At this time, I want to shift over to Angie. Angie, if you want to get started.
Thank you, Marcia. Thank you, Nate, and thank you for giving us the opportunity to be able to partner with you all and to integrate this into holistic juvenile justice reform for justice for immigrant youth. My name is Angie Young. I'm a supervising attorney. I've been here at the ILRC for 13 years, and I'm joined by Rachel Prandini. She's a staff attorney and specializes in immigrant youth issues, and particularly spends a lot of time working in both the delinquency and child welfare systems. Some background on our organization. We are a National Resource Center. We're based in San Francisco, Texas, and Washington, D.C. So we work in very different kinds of climates around immigration issues. Kind of our bread and butter really essentially is a resource center on immigration law and policy. And we work with a broad range of stakeholders and systems to be able to share information about how to best serve immigrant youth and families. And that includes attorneys, justice system partners, judges, prosecutors, defenders, law enforcement, probation, sheriffs, as well as immigrants themselves. So we work with a broad range. And we do, in addition to kind of supporting folks doing this work, we do policy advocacy as well, and work with strengthening these immigrant communities. In particular, just as background, ILRC has been a national expert in the intersection between immigration and the justice system. We actually put the first training of its kind in the 1980s nationally on these issues. And over a decade ago, we started to look more deeply into this connection between the youth justice system and immigration. And I had the opportunity not only to trace some of the cases that we were seeing on the ground, but work with federal agencies to see how young people were entering the system from the youth justice. And then finally working with a number of sites, both JDAI and non-JDAI sites, to see what exactly is happening to immigrant youth and why. So today, just to give you somewhat of a roadmap of what we're doing is, obviously there's been tremendous changes over the last year that we want to share. And we are going to share probably the most prevalent changes and how they specifically apply to the youth justice system today. This is not only for immigrant youth themselves who may lack status, but we know many young people have status, but their parents themselves are undocumented, and they're at greater risk for deportation. And that fundamentally affects some of the outcomes in these cases about how families are supporting and being involved in the system. And so we want to kind of share what are the high levels of anxiety and concern and where they stem from. So in addition to kind of sharing this context that we're going to do for the youth, we'd like to talk about what are the specific issues and challenges, and particularly some of the legal issues facing non-citizen youth. And then we want to close it out by sharing really 5 tangible recommendations that you can take away from and apply and look in this work. Obviously, you're going to have to look at your own demographics and policies and practices, and everything will depend on your jurisdiction, but this is just kind of a blueprint for where you can go as a next step. So I'm going to turn it over to Rachel now, who is going to start us on the current context.
Great, thank you, Angie. So I'm going to provide what's going to have to be a brief overview of sort of the current political context facing non-citizen youth and families, because there has been so much activity in this space recently. But we're going to talk about how it's impacting young people in ways that are relevant to your work in the juvenile justice system. So to get that started, I think it's helpful to understand the scope of this issue. And here I'm actually pulling from the study by the Annie Casey Foundation that Nate referenced, the Race for Results Policy Report, to look at and just understand the scope that we're talking about here when we talk about immigrant families. So that study found that 24% of children in the United States come from an immigrant family, and that's defined as a family with at least one foreign-born parent. 88% of children who live in immigrant families are themselves U.S. citizens, though, oftentimes because they were born in the United States. So it's really a much smaller percent of children who are themselves undocumented or have some other type of lawful status short of citizenship in the U.S. Because of that, we have many children living in mixed status families. So as Angie sort of foreshadowed here in terms of changes to immigration policies that we're seeing, even if they're not directly impacting children who themselves may be U.S. citizens, if they have a parent who's undocumented, that profoundly impacts the family. The overwhelming majority of children, 95% who live in immigrant families, live with parents who have been in the country, in the United States, for more than 5 years, and most have been in the U.S. for 20 years or more. So we're talking about families that have really lived in the United States for many, many years and are really part of the community here. So what is happening in terms of changes to immigration policy? Well, there has been a lot of changes happening, and if you look at the news, you can see that immigration is in the news on a daily basis these days. So you're probably all aware that President Trump has signed multiple now executive orders on immigration policy. So these don't change the law on immigration, but they impact how immigration laws are actually followed and implemented in ways that certain people or categories of people are prioritized or not prioritized. So these executive orders really only single out children and youth in the context of unaccompanied minors, which we'll talk briefly about later, and in the context of DACA youth. But the scope with which they go after sort of any and all undocumented people in the United States is impacting children and youth in profound ways. So there are a few particular ways that the executive orders have done this. The first is that the executive order that was signed last January that talks about immigration enforcement inside the United States, it set out new priorities for who the federal government was going to target for immigration enforcement. So under prior administrations, we had immigration enforcement priorities set out. And these typically, at least in theory, had distinct categories of people that the government was interested in prioritizing to go after for immigration enforcement, meaning arresting and putting into deportation proceedings. In the past, these were focused on people who were seen as threats to national security, typically because of serious criminal convictions. However, with the Trump administration's new enforcement priorities that were put into effect last year, these priorities are so broad that they really apply to any undocumented person in the United States. So in some ways, it's difficult to even refer to them as priorities because they basically just say, if you're undocumented, or even if you have a green card or something like that, but you're not a citizen, and you're deportable, you are not safe, and we are going to focus on trying to deport as many people as we can. The way that they're written, they do say that they prioritize people who have been convicted of a criminal offense, but also people who have been charged with, even without a conviction of a criminal offense. And in addition to that, people who have committed acts that constitute a chargeable offense. So that could be any of us, you know, who have ever sort of sped or violated any kind of law, even if we've never been arrested for it. That could make people an enforcement priority. And this is written so broadly that it does also apply to delinquency. It's not focused just on adult criminal convictions. And so there's no exception for children or youth whose cases would be handled outside of the criminal justice system. And we're not seeing them treat children differently the way that that has been done in prior administrations. In addition to that, throughout the Trump campaign and administration, we've seen a focus on what Trump has referred to as gangbangers, and we see them singled out, and the federal government arguing in many cases without evidence that many of them are undocumented and that they should be removed from this country right away. So we, you know, for example, there's this story that has been in the news about a young man in Seattle, Daniel Ramirez Medina, who was a youth who had DACA. And DACA, just really briefly, we'll talk about it later, but you probably have also heard of DACA in the news. It's been all over the news lately, but it was a program put into place during the Obama administration that allowed certain young people who were brought to the country at a very young age to be able to get temporary protection from deportation and work authorization if they applied with the federal government, so provided all of their information to the federal government and went through background checks to ensure that they had no serious criminal history. And so the government, you know, basically for those people said, if you come forward and give us your information, we're going to give you temporary protection from deportation and work authorization during that time. Well, despite that, they did arrest this young man, Daniel Ramirez Medina, and other youth who have DACA who have been in the news as well. But in this case, it was on gang allegations. So they alleged that this young man was gang involved and that he was a self-admitted gang member. He has no arrest or conviction record, and his attorneys say that he unequivocally states that he is not gang involved at all, and that he was actually pressured by the federal government immigration agents to admit to gang membership. So this is just kind of give you an idea of what some, you know, non-citizen youth are up against under this administration. And the other thing that I want to highlight with these new really broad enforcement priorities for immigration is that many children's parents are now a priority for immigration enforcement, even those who have never been arrested or convicted. And that's something that we just did not see much in prior administrations. But in this administration, they have said, you know, if you're undocumented, you should be scared of immigration enforcement because you're a priority for arrest and deportation. So what this means is that we have children and youth, even those who are U.S. citizens themselves, who are having to live in constant fear of their parents being arrested and deported by immigration agents. This is producing high levels of anxiety and depression for youth. Studies are starting to come out, and you know, the American Pediatrics Association has come out and said they're seeing toxic levels of stress among young non-citizen youth because of the sort of constant fear that they have to live with that their parents may be removed from them. And it also creates a culture of fear in the immigrant community, where individuals and families are often afraid to do anything that they think could expose them to any heightened level of risk of being arrested by immigration agents. And that includes things like sending children to school, accessing public benefits even when the U.S. citizen children are eligible for them, participating in the census, and then importantly for your purposes, also hesitance to report crimes to the police and to cooperate with law enforcement because of the fear of what that may lead to for their family. And in the case of children who are involved in the juvenile justice system, I think families are and will be much more hesitant to participate in case planning for their system-involved children because of this fear that Angie will talk about later, and confusion around, you know, does local law enforcement work for immigration agents or not? So again, what we're seeing is that these quote-unquote priorities are so broad that really everyone is at risk, and this is creating a culture of fear in the immigrant community and has a huge impact on children and families. And for your purposes, this really includes the willingness of youth and families to work with juvenile justice officials, and it impacts the well-being of youth. And we could see that that results in increased numbers of youth, I think, facing the destabilization of their families and potentially ending up in the juvenile justice system. So the other way that we see children singled out in these executive orders on immigration is that they actually do target unaccompanied minors. And many of you probably have heard of this term, unaccompanied minors. In 2014, the numbers of unaccompanied minors coming to the United States really skyrocketed. As you can see on this graph here, there were almost 60,000 children who arrived at the border without a parent or legal guardian in 2014, and similarly high numbers in 2016. And these youth, in almost every instance have experienced pretty high levels of trauma, either in their home country, which was the reason that they fled their home country to begin with, or even if not in their home country during the journey to the United States, many of them have experienced instances of trafficking or sexual assault or rape or other forms of violence. And then essentially these youth are processed and thrown into our culture and educational systems here and expected to not have any problems. However, when problems do occur, it's important to know that these young people will come into our local system. So whether we're talking about child welfare systems or the juvenile justice system. And these are kids who have high levels of trauma. So the executive orders on immigration that we saw from 2017, they actually promised to narrow the pool of who will be considered an unaccompanied child. And that is important because when a child is deemed unaccompanied, it actually entitles them to quite a few legal protections that really help the child to be able to get immigration status in the United States. So this is another way that we see the Trump administration targeting young children. And then the other way that we see children singled out is has to do with deferred action for childhood arrivals. So this is something that has been all over the news. So I'm assuming most people have at least seen, headlines about this. But President Trump rescinded the deferred action for childhood arrivals program in September of 2017. And again, this was a program that was announced during the Obama administration. It provided temporary protection from deportation and 2 years of work authorization to young people that they were able to renew every 2 years. It never provided a path to permanent residency or to citizenship. It was just this sort of temporary protection from deportation. This entire program was rescinded in September of last year. And so now young people who were brought to this country at a young age can no longer seek protection from deportation through DACA. So this is a huge loss for young people in our communities. However, because of a couple of pending and ongoing lawsuits, young people who have been granted DACA in the past or who have it now are still able to renew their DACA requests for the time being. But this is an area that is constantly evolving. So we do suggest that if you work with young people who have DACA, which I think it's very likely that you do, that you really monitor this closely to understand what what the changes are, because this is changing on a weekly basis in many cases. Okay, so I'm going to pass it back to Angie to also talk about some other things that we're seeing in the current context for immigrant children and families. Oh, Angie, we cannot hear you right now. Just make sure that you're...
Thank you.
There we go.
Thank you. I wanted to just say that we have worked with a few JDAI sites that have done some general education information for families and communities about DACA itself and kind of the updates there, and have been involved in some of those efforts. I wanted to now focus on what are some of the developments around immigration enforcement as they relate to the justice system themselves. Not just immigrant youth and families directly, like how is this government actually looking at them? So this is another one of the big headlines beyond just kind of where Congress is at and trying to pass immigration reform, is that there have been, it's been a few years of discussion about the role of what we call sanctuary cities. Sanctuary cities is not defined. Even in the executive order, they do not define sanctuary cities. It's so broad that it can fit so many different places in the United States. It was later defined, though, in a lawsuit as any jurisdiction that willfully refuses to comply with a federal law, which is at 8 United States Code 1373. And the gist of that code is essentially that no local government can prohibit the sharing of information relating to immigration and citizenship status with the federal government. So they say prohibit. They can't require it, but it's a way of kind of getting around. And so I just want to say here, I think the main takeaway from this scenario that you probably can see a lot in the news is that multiple cities and counties have sued against the executive order and any threats to funding decreases as a result of being labeled a sanctuary city. And there were a total of 6 federal court decisions already that have ruled against the administration's attempts to strip federal funding based on sanctuary cities. So while they continue to kind of launch attacks, they have been losing in federal courts. The executive order right now defunding sanctuary cities is enjoined. The Department of Justice right now is doing some workarounds by adding strings to existing law enforcement grant programs. They're mostly the Burn JAG program, so you may want to look at what's there. But most of these conditions have been enjoined as well. And so kind of we're waiting to play this out. The federal government has sent some letters to many, many jurisdictions. There's been rolling basis of letters saying, we think you're out of compliance with, this federal law. Please show proof of why you're not. And I will just say is the allegations in these letters have been very overbroad. They basically extend to information that's not even in the law itself. And so we think that these are things that are kind of a way to threaten but aren't actually have the basis in law. So we continue to track these lawsuits on our website. You can see these updates as you go on. And I guess the most recent update that you should all know that has just happened is essentially that the federal government sued the state of California. Just as, the last administration had sued the state of Arizona saying they overstepped their bounds in getting involved in immigration enforcement, and that's the purview of the federal government. Now they're saying, kind of using the opposite, saying California is probably not involved enough or is obstructing federal immigration enforcement. So, this is a kind of a question of the state versus federal rights. And we're going to see how it plays out. But I know California is mounting a very strong defense for the state. Next slide, please. The other kind of changes that have happened, and this is in the guide itself, is that the administration is increasing pressure on local law enforcement to engage in immigration enforcement. Why? Why is the administration focusing so much on sanctuary cities, on the state of California, and these programs? It's because without these kinds of agreements and coordination, they can't get to the numbers of deportations that they want to get to. They don't have enough ICE agents, even though they are arguably increasing, to be able to enforce all of the immigration laws across the country. So in order to kind of ramp this up, not only by threatening local jurisdictions, but they also have been using a number of programs. And I'll just summarize quickly without a lot of details, but they're restoring a secure communities program that was ended by the last administration. It basically, any fingerprint that's taken by any individual is shared with the Department of Homeland Security. It gives them a technological presence of immigrants around the country. It seeks to increase 287G agreements. This allows local law enforcement to act as immigration agents, and I have a slide on that next that I'll share. And then finally, the criminal alien program. It's the oldest, largest immigration enforcement program in the United States. They're looking to increase it. It basically is information sharing, allowing ICE officers in jails and juvenile halls. It's tracking people through kind of other more informal data that's not just fingerprints and other biometric data. And then we are seeing unprecedented targeting other parts of the justice system, and I'll talk about that in a moment, courts and probation. Probation, we have just gotten a federal FOIA requests in which we saw increase work with probation agencies, which has not been as prevalent in past years, and then obviously targeting of people that are going to court themselves, both civil and criminal. Next slide. I wanted to tease out a couple of things that I just mentioned really quickly, is that the 287G expansion of this agreement, I wanted to say that these 287G agreements are the deepest kind of coordination with the federal government than you can get to in immigration. Why is that so? It's because through federal training and federal supervision, local law enforcement can become basically de facto immigration agents at county and local expense. The federal government does not pay locals to act as immigration. They do it on their own. And this is voluntary. You know, some people disagree. They want to be more involved in the immigration force, and so they do it at their own expense and agree to take that on. And the Trump administration doubled the size of this program. There's currently about 60 agreements, but at least 20 currently in the works. We just found out again from a FOIA request that 60 or so more jurisdictions have expressed interest, including in an old model. So this doesn't only include jail models where there's sheriff jail agents that act as immigration agents, but actually police officers on the streets could act as immigration agents and ask for immigration status. So that has seemed to be an interest. The final thing I'd like to say about kind of where enforcement has moved under this administration is these courthouse arrests. And so many people have been hearing, probably you can just Google this, some searches around how ICE has targeted people that have come to court to show up for a hearing but then got deported. Actually, Marcia and I did a panel at the JDAI conference last year, and we had heard from one state, one of the judges had told us that they saw ICE in the juvenile court themselves and had been targeting young people. This is of grave concern because it really does prevent access to justice for children and families. We didn't know what the official policy was, and then there was a policy that did come out on January 10th of this year. And basically, they say that they will engage in immigration enforcement inside courthouses against targeted individuals, people that they've looked for, but will not target other immigrants encountered absent special circumstances. They're supposed to be not doing this in non-criminal courthouses, but there's exceptions for that. And they are supposed to be doing this in non-public areas of courthouses, probably not in hallways in the courts themselves, but in private areas. But as we know, there has been a number of incidents where people have been taken in hallways, stairwells, and other places. Again, all of those updates things are rapidly changing. You can go to our website and we'll share the link at the end to kind of get those updates on there. I want to move into our second section to briefly talk about how this all applies in the youth justice system, how are non-citizen youth being exposed to some of these issues, and where there is some leverage at the local level to kind of separate these systems. And I guess the first thing just to recognize is that there's disparate impact of arrest on immigrant youth. A youth who is arrested is going to be more exposed to immigration enforcement and deportation than a young person that isn't, obviously. It is one of the gateways to deportation. We just worked on a case recently out of Harris County, Houston, the fourth largest school district in the country, where a young man got in a school fight with a young girl who was basically yelling racial epithets at him. And he fought with her. He reported himself to the HISC school police, and instead of just kind of resolving this issue, they arrested him. He was 18, so they took him to the sheriff's office. The sheriff's office turned him over to ICE, and now he's been in detention for 2.5 months now. This young man had was undocumented from Honduras, has been here for 10 years, and unfortunately too, he had 2 scholarships and 2 offers to go to 2 universities in the state of Texas, but now that's all on the line. And so this is just another example of how, like, any enforcement, including in schools, can lead to deportation, where you get fingerprints shared, your criminal record, you get interviewed, and then ICE has access. Next slide. Detention also has a disparate impact. The more likely immigrant youth are detained in a hall, the more likely that they'll be exposed potentially to ICE flagging, labeling them, and taking them. In our experience, we have seen many cases in which, under the risk assessment, a young person that was a non-citizen was detained where we would think that a U.S. citizen on comparable charges would not be detained. And that was all because of the specter of an immigration issue. And what that leads to is if there, is what we call an ICE detainer, we'll talk about in a moment, it's a request from ICE, it's just a request to notify and hold them after they would be otherwise released. This ensures the transfer of that young person's body to the federal government. And so detention is a great risk factor, as we know, for all youth, but particularly for immigrant youth, it exacerbates this situation on immigration. There's a number of ways in which information is shared. You can take a look at this later. They shared juvenile biographic data, fingerprints are shared. You can share notice of release dates, juvenile records, booking lists, and fingerprints. We'll talk about later on, while this has been some practice in places around the country, we have this prevalent practice for many, many years in California. We see this often as kind of bumping up and violations of state law, where we're talking about juvenile confidentiality. How is it that this information is protected from general public, but then yet shared with a federal agency to deport young people? Next slide. Two things I'd like to say in terms of just clarifying the law before turning over to Rachel is that the federal law doesn't require law enforcement to notify ICE of youth who's suspecting of lacking legal immigration status. What does this mean? This is just the premise of state and federal rights, right? That the federal government can't impose on the local governments or state governments to do the federal government's job. I mean, there's just a basic premise there under the Constitution. So there's also no duty to ask about immigration status. In fact, many youth don't know their status. We have worked with folks in different sites where the youth didn't know their status. They got flagged for immigration, a call was made, and they actually had status. That's liability for local jurisdictions when you start to engage in immigration enforcement. Next slide, please. The second other really important point is that the federal government cannot require state or local facilities to hold or detain youth for immigration purposes. This is the whole sanctuary debate. The federal government is upset that, like many states, have decided not to hold immigrants, including youth, under these detainer requests because they are requests, they're not mandatory, and they often pose liability for local jurisdictions. So there's not a requirement here. You can if you wanted to, but there are issues in potentially doing so. Next slide. And these immigration holds, I'll just say one thing as background because we'll get to this in a moment. Their request, it's on a form called I-247. It asks the local hall to detain a young person or a person for up to 48 hours, past the time they would be otherwise released. It is not a criminal warrant. It's not based on probable cause of a crime. It's not signed by a judge. It is a basically piece of paper signed by an immigration agent. And the key lesson of walking away from this has been these detainers have been held unconstitutional by multiple federal courts over the last years. We have a list of all these court decisions on our website that you can look at. And this is one of the main reasons why people or jurisdictions have not decided to fully engage in immigration enforcement, because of the liability issues of constitutional violations that this imposed by engaging in federal immigration enforcement work. So I'll turn it over to Rachel. This just shows you some of the numbers. Over 700 counties don't hold people for ICE. So this is something that has shown, and we have a national map of the state of local jurisdictions and what they're doing regarding immigration detainers.
Great, thanks, Angie. So I just want to quickly mention before we move on to some of the practice recommendations, what happens to kids if they do get referred to ICE. So if they are in the juvenile justice system and then they end up getting, becoming subject to an ICE detainer or hold or somehow otherwise tipping off ICE of their lack of immigration status, and then sort of what happens to them on the immigration side. So this visual that you see on the screen portrays the maze that children get sent into if they are referred to ICE. So oftentimes youth end up being detained in immigration detention far from their family and support systems. And that is true even though that in almost all cases, youth later are released back into their communities. So this means that they miss months of school, of the ability to comply with probation requirements and all of this, even though in the end they typically get released back to their family and the community to continue to fight their immigration case. When they get placed into immigration detention, of course, they also get placed into deportation proceedings. And in the immigration system, there's no right to counsel, and there are limited ways legally to fight against deportation. So this can have, as you can see, really profound consequences for non-citizen youth. And while juvenile adjudications are not actually considered convictions for immigration purposes, which is this really great thing under immigration law, so they don't have the same dire immigration consequences as adult criminal convictions, they do negatively impact youth's chances of getting immigration status in a few really important ways, and in ways that we're seeing become more important under the Trump administration. So these include, first, that despite the fact that juvenile adjudications themselves don't disqualify youth from being eligible to get immigration status, in certain cases the conduct that underlies the adjudication can trigger immigration consequences. And the most important one here is drug trafficking or sales offenses. When a youth has a drug trafficking or a sale adjudication, the government can use that to argue that the government has reason to believe that the youth is a drug trafficker. And that can actually bar young people from getting many types of immigration status. So that can be very problematic. And then the second and really important element here is that since most ways to get immigration status for young people, such as asylum or being able to apply for a green card through special immigrant juvenile status, since these are discretionary, any evidence of juvenile conduct can be taken into account for discretionary purposes. And so juvenile adjudications will impact the youth's immigration case in that way. And here, really the most damning types of offenses from the perspective of the federal government are any that suggest gang membership or affiliation. That is a huge priority of the federal government and can very much derail a youth's possibility of being protected from deportation and getting immigration status, as well as sex or drug-related offenses can also be very problematic. Okay, so we want to end with some practice recommendations, and these are all set forth in the update to the Non-Citizen Youth in the Juvenile Justice System guide. And really the idea here is that in the current context of increased immigration enforcement that we've been describing, it's so crucial for juvenile justice officials to understand the important role that they play and the potentially serious and negative consequences of local policies that they have on non-citizen youth. So the first practice recommendation is to not enforce ICE detainer or hold requests. So as Angie explained, a few moments ago, federal courts have held that detainers are not mandatory. In addition to that, federal courts have also held that local law enforcement can be found liable in certain circumstances for monetary damages for unlawfully holding people on ICE detainers or holds because they're not required to hold them. And a new report that our organization put out has found that over 700 jurisdictions nationwide have moved away from holding people, and they actually don't hold people for ICE. So essentially, given the questionable constitutionality of ICE detainers, the potential liability that they create for local jurisdictions, in addition to the risk that cooperating with ICE in this manner will undermine community trust in local law enforcement, juvenile justice officials should not hold people for ICE, should not hold young people for ICE. Did you want to say something, Angie?
Yeah, I just wanted to say that there was a decision this week in Texas on a statewide law called SB4. It's a law that kind of coerces local law enforcement to engage in immigration enforcement. And I just want to say, well, in the state of Texas, if anyone is on the call, you can't have a policy across the board not to honor ICE detainers. The Fifth Circuit decision does still allow to look at a case-by-case basis on these ICE detainers, as they can raise constitutional and other legal deficiencies.
Great, thank you. So the second practice recommendation is that local jurisdictions do not enter into 287G agreements. So as Angie explained, these are agreements between the federal government and local law enforcement officials that allow local law enforcement officials to basically be deputized to act as immigration officials. These types of agreements really further confuse the distinction between local police and ICE for the community, because when they interact with a local law enforcement official, they don't know if, how that's going to impact their own immigration status and if they may face deportation as a result. This really impedes the immigrant community's willingness to report crimes and to cooperate with juvenile justice officials. So we recommend that local jurisdictions do not enter into these types of agreements. Third, we encourage everyone to become aware of your state's confidentiality laws in detail and ensure that you don't violate them in sharing information with ICE. So many states do have laws that protect juvenile information in the juvenile justice system, and these laws often don't have any exceptions for sharing information with ICE. So advocates should be sure to be familiar with the laws in your jurisdiction and make sure that you are not, unknowingly violating state law in sharing information with ICE. The fourth recommendation is to continue pursuing JDAI reforms. This means safely reducing reliance on locked detention, given that even a short stay in detention can cause young people serious harm. And as Angie explained earlier, it can significantly impact non-citizen youth in that it can lead to increased chances of being arrested by immigration officials and then transferred into immigration detention, which many times can be much longer than detention in a local facility. So less reliance on detention keeps non-citizen youth out of this deportation pipeline, because typically when youth are referred to ICE by juvenile justice officials, it's while they are detained. We also encourage school and law enforcement officials to reconsider school discipline practices. This means looking to our alternative models for school disciplines that do not rely upon police or school resource officers to handle disciplinary situations. While this is important for all students, in schools it's even more crucial for non-citizen students, because youth could face deportation as a direct consequence of an arrest that happens at school. And I think Angie really illustrated this earlier with her example of the recent arrest of a young person in a Texas school. We also have a resource that talks more about this school to deportation pipeline, and there's a link to it in the resources slide at the end. And then the last practice recommendation that we want to share with you is that we really strongly recommend that you, in order to support youth's successful transition into adulthood and their overall well-being and stability, that you help non-citizen youth in your system to obtain immigration status. There are special ways for children and youth to be able to get immigration status, including those listed on your screen right now. And in the 2014 guide, there's detailed information about these different paths to getting legal status. And then we also have some updates on different of these forms of relief in the 2018 guide as well. So keep in mind that you, as a juvenile justice professional, may be the only person in a young person's life who could potentially flag for them that they're eligible to get immigration status. And if you can refer them for immigration legal services, that can be a life-changing thing for that young person, because it will allow them to get work authorization, to be able to pursue higher education, and to have this stabilizing force of immigration status in their life. I'll turn it back to Angie if you want to take us through the resources that are shared here.
Yeah, and I want to add one here that I didn't put in, sorry. So we have the 2014 guide of the non-citizen youth in the juvenile justice system. It is much more comprehensive than this update. This update only updated the parts that we felt like were necessary in the last year. And it takes you through kind of the background on immigration laws, immigration status, the role of detention, what is immigration enforcement, a lot of the things that we covered today. And then we also have some other resources that you can look at. We have a school to prison to deportation pipeline. resource that talks about how young people may be exposed to deportation through school policing. We have some confidentiality resources. AB 899 is a juvenile confidentiality law in California. You can look at that, and there are interpretations of that. You know, there are other laws, obviously, in other states that we haven't analyzed, but there's something to look at, and you can kind of use this as a template for understanding how this might interact with immigration enforcement. We have a quick reference sheet on the immigration consequence of delinquency, what triggers, what's not. Two other things that you should look at our website, they're just general pages. At ilrc.org/immigrant youth and ilrc.org/enforcement, we have a number of other resources. On the immigrant youth page, one thing that could be of interest to you is we have a Know Your Rights and Responsibilities guide for immigrant youth. We did a focus group with a number of young people to understand, like, what are the questions that they have about their status and what they should be doing. And so it talks about a lot of things about just, you know, driving, military service. What do they need to be able to do to kind of prove to get legal status in the future? What do they need to do once they do get legal status to protect themselves? And then finally, our enforcement page is the page that refers to many of the resources that I discussed earlier. We have a national map of what immigration enforcement looks like in counties across the country. It doesn't take into account in probation, unfortunately, because we haven't gotten that information. We're increasingly getting it now, but it's more like sheriffs, but you can get an understand of like the lay of the landscape of your jurisdiction generally, and maybe the feelings that are happening with the community there. We also have updates on all the legal issues that have come up and we're going to keep updating it with the new stuff. So it will share some of the new developments that we put in this update in the 2018, and you can continue to track it there. Yes, someone just asked for a copy of our slides. We definitely will, and what I'll do is I'll ensure before we send this out to put a couple other links that I had just mentioned now.
So thank you very much, Angie and Rachel. You've covered a lot of ground, and I myself, you know, I have to constantly be reminded that there's new information coming through almost on a daily basis. So I appreciate what the ILRC does to keep us updated. Any other questions that folks want to ask? You can definitely place this in the chat box, and we would be happy to ask. A question that I had received is, do you have jurisdictions that you could say do these recommended items? And what are some of the challenges that you think jurisdictions will come across as they do this work? And then also there is a new question here online, but we can get to them. We have maybe about 9 minutes.
Okay. Let's see here. Can we get the, so Marcia, can you repeat again the beginning part, like in terms of the jurisdiction, model jurisdiction? What are the jurisdictions that do some of this? So, you know, in the work that I've done, and I can't pretend to know that of all of the sites of what we've done, but we know that, I mean, I know the sites here across California because of a state law that I referenced, the JDAI court sites, you know, I've visited Multnomah County, Cook County, Bernalillo County, Santa Cruz County. There's some others as well, have really stuck to the principles of we're going to treat all youth. In some ways, we know that they're differently situated, but they're gonna provide all the services and stick to the JDAI principles for all youth. That may take into certain circumstances, immigration issues and things. We have been trying to work with some jurisdictions to talk about what could that look like to support these youth, just as we talk about working with girls in the system or LGBTQ. There's specific needs that we need to address, and some of that requires, you know, other culturally competent services or translation or things that we want to consider as well. And so I think that I think one of the biggest concerns I would say in this moment and in the past is that we've seen a deviation from what we know are good reform principles that really ensure the best outcomes for young people by kind of applying a whole separate analysis because the specter of this immigration issue. And so I think that that's something we can go back to. And then what are some affirmative steps that you can take that, or at least supports the youth and their families to stabilize their immigration situation? It's not that you're working on the case, but important critical links to resources and communities can make all the difference for a lot of these young people. And I would just want to say, for those people that feel a little scared of being like, are we skirting the law or not? We're actually just informing a lot of these people about their rights, which is not prevalent. I mean, there are rights for these young people that actually get legal status, and many of them do not know that. So I think in some ways we are really ensuring that the law is complied with in its full form as well.
Thank you. There is a question here that said, with the current administration, what happens when processing PRUCOL paperwork?
PRUCOL. I can start that, and Rachel, you can actually just add if you want. PRUCOL is a process. I mean, I'm sure most people know. A lot of people don't always know. It's permanent resident under color of law. It's usually a process in which you kind of certify that someone would apply for legal status in the future, and you're kind of sending it in as kind of evidence of obtaining some benefits further. And so you do that PRUCOL form requires you to send it to a government agency. I can say that from our local, we have liaison with the federal government, or we've had it in the past. And in those liaison meetings, they told us that they get these PRUCOL applications and they put them in a room, and they just stack up, and it doesn't really go anywhere. We can never promise community members that they will never use this information. And if you look at the PRUCOL document, it's pretty extensive. They ask for all the addresses, names of family members. So, you know, we can never make guarantees, but I know that this is part of the process in order to get some benefits at the local level. That is something that we want to be vigilant about, and we'll definitely share updates if anything changes. Rachel, do you have any other things or recommendations in that area that you would kind of say? I think it's one of those areas that's a little bit unclear.
No, I mean, I think just as you said, it's just important to let people know, you know, we have never heard of incidents in the past where submitting a PRUCOL application has led to someone, you know, being arrested by immigration agents, but we don't have any legal basis to promise that that could never happen. And we know in the Trump administration that, you know, it's kind of all bets are off. But people have to weigh the benefits of doing that, because a lot of times PRUCOL is what's going to entitle them to get services, essentially. So, yeah. And
I just so you know, and we have worked with one JDAI site where they had family members that were not comfortable doing the PRUCOL documentation, and they did not force it on those families to do that because of like the concern about sharing that information and kind of undermine that trust. And so it's not to say that there's an easy answer around this, but I think it takes some creative thinking at the local level to look at resources and other options for some of these families that may exist.
Mm-hmm. Thank you so much, Angie and Rachel. This has been an enormously wonderful opportunity to not only ask you some questions, but to get the latest. The update is available online. You'll see here in the chat box that several links have been added also for the 2014 report. And you can go to JDI Connect and get any of that information. We are just a few seconds away from being at the top of the hour. And I just want to thank you again, Angie and Rachel, to Nate and the Annie Casey Foundation. You will receive a survey right as you close this window. And please, please, so that Beth does not have to call you once again to remind you to take the survey, please do the survey. Thank you so much, everyone, for being here and joining us in this really informative webinar. Talk to you soon.
Thank you so much.
Thank you so much.
Bye.